Hello, 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 and welcome to the Hildebrand Law Firm topic for today. My name is Attorney Matt Kaplan, and who is my special guest today?
Hello, I'm Attorney Daron.
Derek is the probate partner here at Hildebrand Law Firm. Kirsten is off solving problems, solving crimes, doing what she does best. And so I asked Derek here to fill in to give us a talk and give us some insight about the joys of probate. Now, Derek, tell me, how joyful is probate?
Probate is not very joyful at all. We typically say here that if you want to pay Matt for an estate plan and do the estate planning right and make sure that everything is set up for your children or your siblings or whoever your next of kin are, definitely do that. If you don't want to pay Matt, then you can pay me. My kids do need to go to college too, so that is appreciated, but that process takes so much longer, costs so much more. And in general, the number one thing that we like to try to do is to avoid probate. If you need me, I am here, but please go through Matt where possible.
Now, Derek, thank you for talking about avoiding probate, because a thing that I get from clients a lot is I don't need a trust. I have my accounts set up as XYZ, payable on death, transfer on death, designated beneficiaries. One thing I wanted to get into in this video is to talk about why it may not be the best plan to just rely on those designations, why a trust might be a good idea, but I want to hear some stories from you of some situations in which people just relied on these beneficiary designations and then things kind of didn't go as planned. So do you have any fun stories for us?
Sure. I can tell you about a family that I worked with a few years ago. We had 5 children in this family. Mom passed away. She had a will. However, she did a transfer on death deed to one of her daughters who was potentially there taking care of her. We never really got into those details because what ended up happening was Mom signed that transfer on death deed and then stored it immediately in a briefcase without ever having it be recorded with the register and probate. And so a couple months after Mom's death, we came across this transfer on death deed. And unfortunately, according to the laws in the state of Wisconsin, if you have a transfer on death deed that is not recorded prior to someone's passing, it is invalid and null and void. And so we actually ended up needing a probate for that case as well, despite the fact that Mom had that advanced planning in place. And certainly if she had a trust, that would have made things easier, but certainly with the payable on death beneficiary, in that case a transfer on death beneficiary, that really did not work out for her in terms of fulfilling her wishes.
Okay, so Mom thought she did everything correct, thought she was going to get it done on her own, and then it turned out maybe she needed a little more help or needed an extra step that she wasn't aware of.
Yes. Yeah, and that happens often. The issues that we tend to have as well with payable on death beneficiaries on investment accounts particularly. You can have an investment agent or an investment banker who will get you the forms, get you everything to fill out. You can sign them. A lot of times they don't require a notary, which is also a bit of a problem in and of itself. But typically then if you fill out a payable on death beneficiary form through an investment banker, you can send it back to that investment banker. But what happens when that investment banker then doesn't send it to the back office to have it be processed? We've had that on a couple of occasions as well too, where even when somebody thinks that they're doing the right thing by naming that payable on death beneficiary on one of their accounts, either someone in the process drops the ball and they don't get that change processed, or what probably should have happened is the investment banker probably also should have followed up to make sure, or the clients or whoever was helping the client should have followed up with that as well. But yeah, what ended up happening was we needed a probate for that as well, unfortunately. And thankfully, those folks were all very willing to work with each other because the way the math worked out is you had this payable on death account over here and these probate assets over here, and they were going to slightly different beneficiaries. And so in order to have this process, we were able to come to an agreement between the beneficiaries after months and months of haggling and going back and forth, thousands of dollars in attorney's fees and drafting this agreement, which actually saved money because had we had to go through a litigation process, we would have had to pay a lot more. And so, yeah, other than being out months and thousands of dollars, that could have worked. It could have worked, but like I said, that investment banker unfortunately didn't process that change or send it to the back office. So, yeah, that was a problem as well.
And so, one thing about relying on those beneficiaries is that you're working off of the assumption that that person is going to be around at the time that you pass away. Do you have any stories of clients in which they relied on payable on death, transfer on death beneficiary, where that individual maybe was out of town, out of touch, or predeceased the other individual? What happens in a situation like that?
Yeah. Well, and with a predeceased beneficiary, it depends, unfortunately. So I can't even give you the concrete answer on that. I have had that same case though with fathers. Both of his sons passed away predeceased. That particular investment firm has baked into their contracts the procedure as to what happens if there is a predeceased beneficiary. And so the example that I'm thinking of actually didn't require a probate because they were able to go to next of kin. But
Okay.
9 times out of 10, those accounts don't have that baked into the contract. Where if you have predeceased beneficiaries, then unfortunately, once again, it goes back through probate. Because then we need to figure out who the new heirs are and whether the person had a will. And because those beneficiary designations don't work, it goes backwards and ends up again going through that probate process.
Okay, so it sounds like then, long story short, you're making a lot of assumptions and you're putting weight into things that you're not sure about by just relying on these beneficiary designations, right?
Correct. Yeah, and we have the age old phrase that I think we've exchanged a couple of times, which is your beneficiary designations forms work 50% of the time every time, which is not something that we want to depend on in an estate planning context, because not only do you have those issues with making sure that they're enforced, making sure that they're properly transmitted, making sure that they're properly processed.
And do
Planning.
the properly processed and transmitted, do those tend to be the most common issues or mistakes with the beneficiary designations?
Yeah, I'd say between that and predeceased beneficiaries, it's probably about 50-50. Because if you do have a predeceased beneficiary, and you've seen cases too where dad is there, he names his son as beneficiary, his son passes away, but because dad is getting up there, he's either subject to a guardianship, maybe has been deemed incapacitated, and so he actually can't go back then and change that beneficiary designation, which is where a trust would certainly be much more useful and come in handy, because the point of that trust estate planning is when you have something that changes, a major life event, then that trust is catching all of those potential eventualities, catching those estate plans. Again, the example of the POD beneficiary, if your POD beneficiary owes somebody a lot of money, and all of a sudden they're getting a bunch of money from a POD beneficiary, there's no way to stop that. And there's no way, in some cases, to intercept the creditor from intercepting your POD beneficiary funds. And so that's another reason why we always say, put it into trust, because that beneficiary designation is going to work 50% of the time every time.
And you've seen that happen where a POD or a beneficiary has been intercepted by a judgment creditor or something else?
Exactly, yeah.
Okay, and what happens in a situation like that? So, how does that work, on the actual ground level?
Yeah, so we had a case a few years back with the state of Wisconsin actually was able to intercept funds from a POD beneficiary because there was a old tax debt that was owed. And so that's another way where a trust could potentially protect those funds from a creditor. Now, it is, again, a legitimate creditor, but did the person want to use those funds to pay off the tax debt at that exact moment? Did they have other needs where those funds would have been more properly served? Probably. So it would have been avoidable had they set up a trust ahead of time.
And keep in mind, too, a lot of the stuff that we're talking about with regards to setting up these beneficiary designations really only applies to what happens to my stuff after I die. If while you're alive, you're concerned, which you should be, about being sued or needing long-term care, those beneficiary designations aren't going to do a darn thing, right, Derek?
Correct, yes. If there's no money in the account to do anything with because you needed it for long-term care or other needs, then that beneficiary designation isn't going to do anything for you.
And one thing that I know I've seen on the Medicaid standpoint and the Medicaid end is when Medicaid does their asset recovery program, they've intercepted life insurance payouts through a designated beneficiary. They've intercepted retirement accounts, POD beneficiaries. They've intercepted transfer on death at the county level. And I'm sure Derek doesn't even want to get into. We're also working off of the assumption that the people at the respective institution and county know what the heck they're doing and know how to execute these situations. So we're going to end soon, but before that, I want to hear, do you have any stories about maybe a transfer on death designation at a county in which the county just didn't know what to do? And so they said, oh, we're just not going to do it. Or maybe they did it wrong, or maybe they put the client through a little bit more stress than necessary.
Yeah, thankfully nothing specific, or nothing so specific as to that. I mean, the beneficiary designations, other than being intercepted at the state level by again, the Department of Revenue has a lot of powers that most creditors don't have.
Mhm.
That they are able to go into deceased individuals' accounts as well, even if they are POD, and go and take those funds, which is where a trust can offer some additional protection.
Okay. Well, wonderful, Derek. Thank you. That is all of our time for today. Derek is going to be back in the next video. We have a range of topics to talk about, from board games to hopscotch. He was going to talk about the Tiananmen Square incident. And we were also going to maybe briefly discuss the Roman Empire if there's time. I know he thinks about that quite often.
Yes.
And so please stick around for the next video, and just know that here at Hildebrand Law Firm, we're here to protect your today and your future. Thank you so much.